much, ladies and gentlemen. Good morning. First of all, I would like to thank very much for inviting me to the research team dealing with the responsibility of the highest state bodies and for the opportunity to give a paper today. First point is opening. Constitutional accountability belongs to one of the most paradoxical institutions of modern constitutionalism. It is designed to control the exercise of power, yet under certain conditions it may also protect those who wield the power. Modern constitutionalism democracies are built upon the assumption to even the highest state authorities remain subject to the constitution and may be held responsible for its violation. At the same time, however, mechanisms of constitutional responsibility are typically designed as extraordinary institutional procedure activated only in exceptional circumstances. The institutional design creates a distinctive paradox. In many constitutional systems, mechanisms such as impeachment or constitutional liability before special tribunals remain rarely used. Yet, during the period of political conflict or constitutional tension, they suddenly become central instruments of institutional confrontation. This observation raises an important theoretical question. Does the practice of constitutional accountability demonstrate the strength of constitutional safeguard, or does it reveal a weakness in the legal mechanisms designed to protect the Constitution? My central argument today is that the practice of constitutional accountability cannot be interpreted solely as an evidence of weakness in constitutional design. However, its operation may reveal the structural tension within the constitutional order, especially when mechanisms designed to protect the Constitution began to function as instruments of political conflict. This is the program of my speech. So I go to the point: constitutional accountability as a principle of constitutional governance. The idea of accountability occupies a central place in contemporary theories of constitutional democracy. In general terms, accountability refers to institutional arrangement through which public authority must explain and justify their action and may face consequences for unlawful conduct. Mark Bowens famously defines accountability as a relationship in which an actor is obliged to explain and justify his or her conduct before a forum that may pass judgment and impose consequences. Within constitutional system, accountability operates at several levels. We usually distinguish between political, legal, and constitutional accountability. Political accountability occurs primarily through elections as parliamentary mechanism. Legal accountability concerns the application of ordinary law, including criminal or administrative responsibility. Constitutional accountability, however, occupies a distinct position. It concerns violation of the Constitution committed by the highest organs of the state, and therefore operates at the very center of the constitutional order. In this sense, constitutional accountability reflects one of the fundamental premises of constitutionalism, that public power must remain limited by law. As Karl Friedrich observed, constitutional government requires institutional mechanisms, ensuring that those who exercise power remain subject to effective control. The extraordinary character of constitutional liability. A distinctive feature of constitutional responsibility lies in the exceptional character. Mechanisms such as impeachment or responsibility before constitutional tribunals are not designed to function as ordinary legal procedure. There are extraordinary instruments intended for exceptional situations. This understanding can already be found in classical constitutional thought. In the Federalist number 65, Alexander Hamilton described impeachment as addressing offenses arising from what he called the abuse or violation of some public trust. The abuse or violation of some public trust. Such offenses, Hamilton emphasized, are inherently political because they concern the conduct of public officials in the exercise of constitutional authority. Modern constitutional theory confirms this interpretation. Bruce Ackerman observed that many constitutional safeguards are designed to operate rarely but exert an important preventive influence on political actors through their very existence. In this sentence, constitutional accountability performs several systematic functions. It protects the Constitution from violation by public authorities. It provides institutional mechanisms for resolving serious constitutional conflicts. And it symbolically affirms the supremacy of the Constitution. For these reasons, the rarity of constitutional accountability procedure does not necessarily indicate their ineffectiveness. The hybrid nature of constitutional accountability. Another distinctive feature of constitutional accountability lies in its hybrid nature. Procedures such as impeachment combine elements of law and politics. As John Elster observes, mechanisms of impeachment historically integrate legal evaluation with political judgment in a single institutional structure. This hybrid structure creates an inherent tension. On the one hand, constitutional accountability must remain sufficiently legalist to ensure fairness and due process. On the other hand, because the procedures are embedded within the political institution, they inevitably reflect broader political conflicts. Martin Gulin has described this institutional space as part of political constitution, where law and politics interact. Understanding this hybrid character is essential for interpreting the practice of constitutional accountability. Next point, constitutional accountability as a shield. Constitutional accountability is usually analyzed as a mechanism designed to control public power. However, it may also perform a less frequently discussed function, that of a protective shield for holders of high public office. This phenomenon results from the institutional architecture of constitutional liability mechanism. First, constitutional accountability may operate as a procedural shield. In many constitutional systems, high officials cannot be prosecuted through ordinary criminal procedure without first undergoing a special constitutional procedure. Second, constitutional accountability may function as a political shield because the initiation of such procedure often depends on parliamentary majority. Third, the mechanism may operate as a systematic shield protecting the stability of the constitutional order itself. As Dieter Grimm notes, constitutional institutions often serve not only to control power, but also to stabilize the functioning of the state. This dual institutional role reveals a fundamental paradox. An institution designed to protect the Constitution may simultaneously protect those who exercise constitutional power. And now, some words about constitutional accountability and constitutional crisis. The analysis of constitutional compatibility must also be placed within a broader theoretical context, the phenomenon of constitutional crisis. In stable constitutional system, mechanism of constitutional responsibility function primarily as preventive safeguards. Their significance, however, may change during periods of institutional instability. David Landau has demonstrated that contemporary democracies may experience process of abusive constitutionalism, in which legal mechanisms formally consistent with the constitutional procedure are used in ways that undermine the substantive principles of constitutional democracy. Similarly, Kim Lane-Sheppel argued that constitutional crises often emerge not through the sudden collapse of constitutional norms, but through their gradual reinterpretation and instrumental use within political struggles. Under such conditions, constitutional mechanisms may become tools in broader conflicts over constitutional authority. Against this theoretical background, several key questions arise. Does the rarity of constitutional compatibility procedure reflect the strength of constitutional safeguard, or rather the structural limitation of a compatibility mechanism? Under what conditions does constitutional compatibility function primarily as a mechanism of constitutional control, and under what condition does it operate as a protective shield? And finally, can the increasing use of constitutional liability procedure be interpreted as a symptom of deeper constitutional tension? Conclusion. The practice of constitutional compatibility should therefore not be interpreted in a simplistic way. Mechanism allowing the highest public authority to be held responsible for violation of the Constitution constitute an essential element of constitutional governance. At the same time, their practical operation reflects the complex interaction between law and politics within constitutional system. It may operate as a sword, protecting the Constitution against abuse of power, but it may also function as a shield, protecting holders of public office from ordinary forms of legal responsibility. The central challenge for constitutional design lies in maintaining an appropriate balance between these two dimensions. Ultimately, the paradox of constitutional compatibility lies in the fact that an institution created to safeguard the Constitution may, under certain conditions, of course, also protect those who exercise constitutional power and not respect the Constitution. Ladies and gentlemen, dear colleagues, thank you for your attention.